Hello everyone, I'm Himanshi Hans. In today's video, we will be discussing some landmark constitutional bench judgments delivered in 2024 by Honorable Justice D.Y. Chandrachud while he was serving as the Chief Justice of India. Let us start with the judgment in the state of Punjab versus Davinder Singh. It was a 7-judge bench judgment delivered on 1st of August 2024. This judgment was delivered by the then Chief Justice Dr. D.Y. Chandrachud for himself and Honorable Justice Manoj Mishra. Honorable Justices B.R. Gavai, Vikram Nath, Pankaj Mittal, S.C. Sharma each delivered separate concurring judgments. Honorable Justice Bela M. Trivedi delivered a dissenting opinion. The State Legislature of Punjab enacted the Punjab Scheduled Castes and Backward Classes Reservation in Services Act 2006. The statute provided for reservation in services for the members of the scheduled castes and backward classes. Section 4.2 of the Act provides that reservation of 25% shall be made for the members of the scheduled castes and 12% for backward classes while filling up vacancies by direct recruitment in services. Section 4, Clause 5 stipulates that 50% of the vacancies of the quota reserved for the scheduled castes in direct recruitment shall be offered to Balmikis and Mazhabi Sikhs, if available, as a first preference from amongst the scheduled castes. Proceedings were instituted for challenging the validity of Section 4, Clause 5 of Punjab Act. The High Court of Punjab and Haryana declared Section 4.5 unconstitutional, relying on the judgment of the Constitution Bench of the Honorable Supreme Court in E.V. Chinnaya versus State of Andhra Pradesh, 2005 Supreme Court, which held that subclassification amongst the scheduled castes for the purpose of giving more beneficial treatment to a group in the larger group of scheduled castes is not permissible. The Honorable Supreme Court by a majority of 6:1 held that subclassification of scheduled castes among reserve categories is permissible for granting separate quotas for more backwards within these SC categories and overruled the E.V. Chinnaya versus State of Andhra Pradesh. It held that subclassification amongst the scheduled castes for giving more beneficial treatment is permissible in law. It held the objective of any form of affirmative action, including subclassification, is to provide substantive equality of opportunity for the backward classes. The state can subclassify based on inadequate representation of certain castes. However, the state must establish that the inadequacy of representation of a caste or group is because of its backwardness. Second, the state must collect data on the inadequacy of representation in the services of the state because it is used as an indicator of backwardness. And lastly, Article 335 of the Constitution is not a limitation on the exercise of power under Article 16.1 and 16.4. Rather, it is a restatement of the necessity of considering the claims of the scheduled castes and the scheduled tribes in public services. Efficiency of administration must be viewed in a manner which promotes inclusion and equality as required by Article 16.1. Moving to the next judgment, in Re Section 6A Citizenship Act 1955, which was a 5-judge constitutional bench decision delivered on 17th of October 2024. The judgment of the court was delivered by Honorable Justice Surya Kant for himself and Justices M.M. Sundaresh and Manoj Mishra. The then Chief Justice Dr. D.Y. Chandrachud delivered a concurring judgment. Honorable Justice J.B. Pardiwala delivered dissenting opinion. This judgment dealt with the constitutional validity of Section 6A of the Citizenship Act 1955. This provision was incorporated in 1985 to establish a framework and to delineate criteria for granting Indian citizenship to migrants who entered Assam before 25th of March 1971. The provision created categories for conferment of citizenship to immigrants who entered Assam. First, deemed citizenship to immigrants who entered prior to 1st of Jan 1966. Second, the process of registration for immigrants who entered between the period of 1st of Jan 1966 and 25th of March 1971. However, by omission, no protection was granted to those entering Assam after 25th of March 1971, thereby rendering their presence in India illegal and liable for deportation under other existing legislation. Expressing the problems that have been posed by the influx of immigration from Bangladesh into Assam, which the petitioners contended have been compounded and legitimized by Section 6A. This issue was before the Honorable Supreme Court. The Supreme Court upheld the validity of Section 6A of the Citizenship Act 1955, which recognized the Assam Accord. It was held that Section 6A falls within the bounds of the Constitution and does not contravene the foundational principles of fraternity, nor does it infringe upon Article 6 and 7, Article 9, Article 14, Article 21, Article 29, Article 326 or 355 of the Constitution of India. Furthermore, Section 6A does not clash with the Immigrants Expulsion from Assam Act 1950 or established principles of international law. It was directed that immigrants who entered the state of Assam prior to 1966 are deemed citizens. Immigrants who entered between the cutoff dates of 1st of Jan 1966 and 25th of March 1971 can seek citizenship subject to the eligibility conditions prescribed in Section 6A, subsection 3, and immigrants who entered the state of Assam on or after 25th of March 1971 are not entitled to the protection conferred by Section 6A, and consequently they were declared to be illegal immigrants. Accordingly, Section 6A was declared redundant with respect to those immigrants who have entered the state of Assam on or after 25th of March 1971. Moving to the next judgment, Sita Soren versus Union of India, which was a 7-judge constitutional bench, and the judgment was delivered on 4th of March 2024. This judgment was delivered by Hon'ble Dr D.Y Chandrachud, the then Chief Justice of India. The bench overruled the verdict in P.V. Narasimha Rao versus State, wherein it was established that the Member of Parliament and Member of Legislative Assemblies enjoyed immunity if they cast vote in the House after taking bribe for it. It was held by the court in this case that bribery is not rendered immune under Article 105(2) and the corresponding provision of Article 194 because a member engaging in bribery commits a crime which is not essential to the casting of the vote or the ability to decide on how the vote should be cast. The same principle applies to bribery in connection with a speech in the House or a committee. It was held that the interpretation in the judgment of the majority in P.V. Narasimha Rao results in a paradoxical outcome where a legislator is conferred with immunity when they accept a bribe and follow through by voting in the agreed direction. On the other hand, a legislator who agrees to accept a bribe but eventually decide to vote independently will be prosecuted. Such an interpretation was held to be contrary to the text and the purpose of Articles 105 and 194. You can also refer to the detailed video on this judgment which is available on this channel. Now moving to the next judgment, Property Owners Association versus State of Maharashtra, which was delivered on 5th of November 2024 by a 9-judge constitutional bench. The judgment was delivered by Honorable Dr. D.Y. Chandrachud, the then Chief Justice of India, for himself, and Justices Rishikesh Roy, J.B. Pardiwala, Manoj Mishra, Rajesh Bindal, Satish Chandra Sharma, and Augustine George Massey. A separate judgment was delivered by Honorable Justice B.V. Nagaratna. Honorable Justice Sudhanshu Dhulia delivered dissenting opinion. To address the issue of deteriorating buildings, the Maharashtra government enacted the Maharashtra Housing and Area Development Act in 1976, which consolidated various housing and building repairs laws. Chapter 8A was added through an amendment allowing the state to acquire old buildings if 70% of occupants formed a cooperative society and paid 100 times the monthly rent. The amendment included Section 1A explicitly declaring that the Act was meant to implement Article 39B of the Constitution of India 1950, which deals with distribution of community resources for common good. Property owners challenged Chapter 8A's constitutionality before the Bombay High Court, arguing it violated Articles 14 and 19 of the Constitution by arbitrarily depriving them of property rights. However, the petitions were dismissed by a division bench of the High Court, upholding the constitutionality of the provisions of Chapter 8A of the Act. The High Court held that the provisions of Chapter 8A are saved by Article 31C as they were enacted to give effect to the principles laid down in Article 39B. The Honorable Supreme Court declared Article 31C to the extent that it was upheld in Kesavanand Bharti as valid. Not every resource owned by an individual can be considered a material resource of the community merely because it meets the qualifier of material needs. The majority disagreed with the judgment in State of Karnataka versus Ranganatha Reddy that private properties can be regarded as community resources. Moving to the next judgment, Paige, Prakash, Pathak and others versus Rajasthan High Court and others. This was a 5-judge Constitution Bench judgment delivered on 7th of November 2024. The judgment was delivered by Honorable Justice Manoj Mishra. A 3-judge bench of the Honorable Supreme Court, while accepting the salutary principle that once the recruitment process commences, the state or its instrumentality cannot tinker with the rules of the game insofar as the prescription of eligibility criteria is concerned, wondered whether that should apply also to the procedure for selection. In that context, doubting the correctness of a coordinate bench decision in K. Manjushri versus State of AP for not having noticed an earlier decision in State of Haryana versus Subhash Chandra Marwa, directed that the matter be placed before a larger bench for an authoritative pronouncement on the subject. So on this, the bench held as follows. First, recruitment process commences from the issuance of the advertisement calling for applications and ends with filling up of vacancies. Second, eligibility criteria for being placed in the select list notified at the commencement of the recruitment process cannot be changed midway through the recruitment process unless the extant rules or the advertisement so permit. Even if such change is permissible under the extant rules or the advertisement, the change would have to meet the requirement of Article 14 of the Constitution and satisfy the test of non-arbitrariness. Third, the decision in K. Manjushri versus State of AP lays down good law and is not in conflict with the decision in State of Haryana versus Subhash Chandra Marwa, Subhash Chandra Marwar deals with the right to be appointed from the select list, whereas K. Manjushri deals with the right to be placed in the select list. The two cases therefore deal with altogether different issues. Fourth, recruiting bodies subject to the extant rules may devise appropriate procedure for bringing the recruitment process to its logical end, provided the procedure so adopted is transparent, non-discriminatory, non-arbitrary, and has a rational nexus to the object sought to be achieved. Fifth, extant rules having statutory force are binding on the recruiting body both in terms of procedure and eligibility. However, where the rules are non-existent or silent, administrative instructions may fill in the gaps. Lastly, placement in the select list gives no indefeasible right to appointment. The state or its instrumentality for bona fide reasons may choose to not fill up the vacancies. However, if vacancies exist, the state or its instrumentality cannot arbitrarily deny appointment to a person within the zone of consideration in the select list. Moving to the last judgment, Aligarh Muslim University through its registrar Faizan Mustafa versus Narish Agarwal, which was delivered on 8th of November 2024. The majority judgment was delivered by Hon'ble Dr Justice D.Y Chandrachud, the then Chief Justice of India, for himself and Justices Sanjeev Khanna, J.B. Pardiwala and Manoj Mishra. The dissenting opinion was delivered by Honorable Justices Suryakant, Dipankar Datta and S.C. Sharma. In 1977, the Mohammedan Anglo-Oriental College was established in Aligarh. The college was a teaching institution affiliated to the Calcutta University at first and subsequently to the Allahabad University. The Aligarh Muslim University Act 1920 established and incorporated Aligarh Muslim University. The AMU Act was amended by the Aligarh Muslim University Amendment Act 1951 and 1965. The amendments related to the religious instructions of Muslim students and the administrative setup of the university. Proceedings under Article 32 of the Constitution were instituted before the Supreme Court for challenging the constitutional validity of the 1951 Amendment Act and the 1965 Amendment Act. A constitution bench in the decision in S. Aziz Basha versus Union of India upheld the constitutional validity of the amendments. The petitioners broadly contended in this case before the court that the decision in Aziz Basha is not correct and that AMU is a minority institution. It failed to recognize that the words establish and administer are not preconditions to define a minority, but the consequential rights that flow from such a recognition. Second, the assumption that the universities lose their minority status when recognized by a statute conflicts with the right of minorities to establish educational institutions. Thirdly, it recognized the role of the Muslim community in the establishment of AMU, but held that its origins and administration were rooted in legislation. This interpretation could restrict the recognition of minority institutions under Article 30. Fourth, its restrictive interpretation of the word establish in Article 31 is contrary to the expansive view adopted by subsequent judgments. Submissions on behalf of the Union of India were: Aziz Basha correctly recognized the choices available to AMU in 1920. It had the choice of either affiliating with another university or surrendering its minority status to the imperial government. Under the AMU Act, AMU voluntarily surrendered its minority institution status to the imperial government. This is shown by the historical context of the Aligarh split, where the institution's leaders chose cooperation with the British government over retaining its Muslim character. The view taken in Aziz Basha that an educational institution is not established by a minority if it derives its legal character through a statute was overruled in this judgment. A detailed video discussing this judgment will also be uploaded shortly on this channel. Thank you so much for watching this video. I hope you understood all the judgments and found the discussion to be fruitful. Thank you so much for watching. See you next time. Bye-bye.